Hello and welcome everyone. Very good afternoon. We warmly welcome you yet again to another edition of Vestralex free online community classes on law. This is a free legal literacy initiative. This is your initiative by you and for you. It's only possible through the gracious and kind and most valuable time and guidance which is provided to us by our seniors at the bar as well as at the bench. Today with us, we have the pleasure of learning from Honorable Padam Shri Pravin H. Parekh, sir. He's a senior advocate Parekh Court. Very briefly, I'll introduce her. Shri Pravin Harjivan Das Parekh is a leading and eminent senior advocate of the Supreme Court of India. He has been formerly the president of Supreme Court Bar Association and has been elected as president 6 times in the past. Sir was born in February 7th. In 1944, Shri Parekh obtained the Bachelor's of Law degree from Government Law College, Bombay in 1965. He came to Delhi in 1969 and soon became one of the leading advocates in the Supreme Court. He founded a law firm called P.H. Parekh & Co., which held the distinction of the highest matter in the Supreme Court for several decades. More than 400 lawyers, all doing very well in India as well as abroad. And this, mind you, is the introduction that we're proposing for sir. Through the Padma Shri, when sir was given the Padma Shri, the introduction is given in that book itself. So it's the same which we are replicating. So mind you, this is a 10-year-old introduction. So there's a lot which has also been added to this. Shri Parekh is the founder, president of Confederation of Indian Bar, founder secretary general of International Institute of Human Rights Society, member of Executive Council of International Law Association, etc. In the past, he has been president of Advocates on Record Association of the Supreme Court for 10 years. He has been elected as vice president of Bar Association of India and was chairman of Consumer Education and Research Center. Shri Parekh has appeared in a large number of cases of seminal importance in the fields of constitutional law, taxation, criminal law, etc. He has represented several leading individuals and organizations, including former presidents of India, vice presidents of India, prime minister of India, union cabinet ministers, chief ministers, government of United States of America, Ford Foundation, Election Commission of India, and various high courts, etc. Shri Parekh has edited and authored a number of books. He is frequently invited to speak at various seminars all over the world in various international conferences. He has successfully organized many national and international conferences on key subjects of public importance like access to justice, legal aid, and human rights. So it is our pleasure. It is an honor to have this opportunity of learning from you today. And so with that, I very humbly hand over the class to you and request you to kindly enlighten us on the topic of do's and don'ts for young lawyers.
Yeah.
So,
very well. There's a question is very good. Do's and don'ts is very, very important. Both are equally important. Now, as far as youngsters who become a lawyer, it is very, very necessary for them to know the law. And by knowledge of law will basically, of course, the constitution, whether it is in their classroom or not. Maybe sometime the constitution will come in a later periods, etc. But that is, everyone should study constitution, because if the constitution is the basic law and everything goes with the constitution. If parliament makes a law which is contrary to the constitution, the court will say, no, you made a law, maybe all parliament members have agreed, but I, as a Supreme Court, will say, sorry, this is unconstitutional. It is contrary to the constitution. So your law may remain in your, as that you have called it that this is your law, but you will not be allowed to function that as a law, because we declare that this law is unconstitutional, or this law is contrary to certain provisions of our constitution. So that is a very, very thing to know about what can be done by the parliament and the state legislatures. Of course, we have got both have legislation. There are certain points are given only to the parliament, and parliament alone can make the laws. There are certain things are given to the state legislatures who can make the laws, and Parliament cannot make the law for those which is given exclusively to the state legislature. And there is concurrent where both can make the laws, Parliament and the state legislature, and they both can carry on. But if there is contrary to the Parliament law, then Parliament law will prevail, and not this state legislature law will not be prevailed. But if there is no controversy with the two things, then both can work together. Now, the young lawyers, therefore, first and foremost, I'd like to say is please understand the Constitution and please various laws. Now, it depends on what the students are interested in. If someone student are interested in the taxation, we should study taxation and go to the N.A. Palkhiwala's book, definitely. He's no more, but he was a great lawyer in the Constitution, and he used to give speeches on the budgets, most of the time criticizing that this budget is no good. If you behave this type of laws, if you make, then nobody will come and nobody will function. And initially, he started making these budget speeches in Bombay, but thereafter he was requested by so large number of cities. He started going to different places. He also used to write. And he was one man, excellent lawyer, excellent thinker. And he all the time saying if there's something is done by the Parliament, he will criticize. If it's done by the governments, central or state, he'll criticize. And he will give the reasons. It's not saying that I don't like this law. He will say why I don't like it, or he will say how it is not constitutionally permissible. There are, in fact, I have not seen any another Nani Palkhiwala as he has seen him, but it's all right. There are many other very good lawyers all over the country. We have a large number of people. Now, therefore, the one thing is about the law. What should be the law? And as I said, and then the other thing which the students should study is to keep on thinking and apply your mind. You are entitled to say that yes, this Parliament has made this law, but I think it is unconstitutional. Now it's too much for a youngster to say it is unconstitutional, but I think he can, provided he's talking properly, he's thinking properly. There, a student can also say that I think this law made by the Parliament is not correct. It is also possible for everyone in our country to say that the judgment of the Supreme Court is not correct. Yes, we can say so. Supreme Court's judgment is not correct because it has not taken into consideration certain laws which would not allow them to make the laws. Or there was some earlier judgment, which is supposing that is of a larger bench. Then the lower bench, by lower, it does not mean lower, but the lesser judges in the they cannot override or write anything contrary to what is laid down by the larger bench of the court. Now, the students, I want them to think that when you are a student, behave yourself that you are a judge and you are an advocate. Think both and keep on thinking. And fortunately, today's students are much better than, of course, when I was, there was people used to go to law because they did not get admission for some other good, they could not go to the doctors or the engineering thing, and say, all right, now I have nothing, so let me go to, and you could get admission in the law college with whatever, even if you had just whatever 35% marks was there, later on perhaps it became 50%, whatever, you could go. But now it is not so. There are a large number of lawyers and large number of people want to start law as their first choice. Now, it is also very necessary because our constitution has been very good and our Supreme Court has made it something more than what the constitution says. If constitution says A, the Supreme Court will interpret and say it is not A, but A plus B is how I'll interpret, and by interpretation, therefore, although Parliament says A, but I will read A as being A plus B. Likewise, but on the other side, if the parliament makes a law, it is the court will say, yes, you have made a law. All the MPs have made, you have a right to make the law. But I, as a Supreme Court, will say that what you have done is unconstitutional. So you might have made all the parliament members, Lok Sabha, Rajya Sabha, both have signed 100%. The Supreme Court can say, two judge bench of Supreme Court can say, my dear Parliament, you have written that, but it is unconstitutional. So I declare as a Supreme Court judge that your law will not be operative. And the day that judgment comes, that law does not become a law at all. It cannot be operative and it cannot be used. So this is the other powers of the courts. And I will not like you powers. It's their duty. They're doing what is there. And it is possible for a long time. The government used to tell that we are elected. Who are you, the courts? What business have you to say and work against us? But that was an old story. Later on, now everyone has accepted, including the parliaments and all the governmental authorities have accepted that yes, this parliament allows the Supreme Court to say what you have done is contrary to the constitution and will not allow you to function this. Now this is very, very good. And the other thing I want is the young advocates, please talk to each other, discuss with each other, yourselves, the students and students together. Forget your teachers, forget the lawyers, but yourself think and say, what do you say? Questions, why, how, what are questions that come to each one of you for all the issues which are being argued before you or which you are reading. And think of the reasons. Now, the reasons can tell you whether, although this is made, is it lawful, is unlawful, it is constitutional, it is unconstitutional. Can the court then say that I will not allow you to interpret in a way, because then that will be unconstitutional. So I will change what the parliament has said to say that it will be this much and not beyond that. So that is how the thing happens. And it is also necessary for each one of you, since your students, I'm talking to students, please note down whatever you think. Like you people all know the computers, When I became a lawyer, there was nothing like computer at all. I mean, what you have got now today is excellence. So you have got this power. Use that power very well and keep it so that you can say, all right, you can get into. Otherwise, good old days, we had to write down everything by hand and say, all right, this is this, but now you have got all this. But what the most important thing I want you to do is think and discuss. If you do these two things, then you will be very, very successful students, because the students should also think of what to do. Now, most of the law students today says that I want to have a government job. I want immediately, I want to start getting money. I think it's not a good idea, because remember that when you pass your LLB degree, you don't know full of the law. Of course, you learn these days. There are good teachers and there are good colleges, but that's not enough. Unless you go and go in the courts and find out what Mr. A is arguing and why, and what B says that no, A is wrong and I am wrong as B. And the court will decide whether A is right, B is right, or maybe partly A or partly B, whatever. Now, therefore, that you must understand that this is law. It's not very simple to say this is what the section says. There are a lot of interpretations are made. When it means A, they will say it is not A, but A plus BBC or A minus DEF. So the court will do. The parliament has not done it. Therefore, in good old days, I said parliament and state legislature were saying that what is this Supreme Court? Why are they harassing us? Why are they getting into our rights? Yes. So, but now they are not talking, because by now it is well known and everyone accepts that yes, the judiciary has the power to interpret and even declare that the law you have made is yes, you have made it, but I will, Parliament, you have made this law, but I, the Supreme Court, will say, I will not allow this law to be function. It will not operate. It will not function. The court will not, citizens will not accept your Parliament, the judgment made by Parliament, maybe unanimously. So it is very, very important that the students please start working, thinking, and write down and note down. You people don't write down or you've forgotten the pen. That's all right. That's good. But you do it in your whatever you want to note down. Please note down. If there is any questions by the students, I'll be happy to reply.
So, very enlightening, actually, very empowering, to be honest, how you started off as well. So, sir, there is one question. Sir, we can either do either of the two things, sir. Either we can take all the questions toward the end. Also, as per how sir suggests, we can between also.
No, I'm all right. You decide what you want. I'm okay.
So, as per your convenience, sir. Every word which comes from you, sir, it is very precious for us. So, ideally, we would not want to interrupt you during any train of thought that you have.
No, but you said now you want them to ask questions or no?
Absolutely, sir. So, there is one question from Mr. Parag Damor, sir. Mr. Parag, would you want to ask, or should I ask on your behalf? So, sir, his question is how to enhance drafting skills.
Yeah, okay. The drafting will you can do properly. Number one, read what has been drafted in the past, what the Parliament has drafted, etc. Find out how those have been interpreted by the courts. The Parliament says A, B, C, and the court can say it is non-A, non-B, non-C. That is not in all cases. In some cases, court say. Or it will say A, B, C should only mean A, B. Or it only means A, etc. So that's by the interpretation. So you must find out when have the courts said that Parliament has made this law. If I read the paper, yes, it is said. And the Supreme Court says that I will interpret that to mean that it does not mean what they have said. Either it is said something more or something less. And secondly, as I said, then the court will say, your Parliament has made this law. Yes, this is the law, but it is contrary to Constitution. So I will not allow this law. Your law may remain in your Parliament book, but it will not be operated by you with the citizens of India, etc. Our Constitution has given rights even to non-citizens certain rights. So that is how it is given, and our Constitution is good. It has been done well, and many times they tried to amend. Some amendments were good for citizens, some were bad for citizens, and what was bad for citizens many times the courts have said you cannot make such a law. But by and large, now the politicians have accepted that I can do anything in my Parliament and the state legislatures, but it is open for the judiciary to say what you have done is not lawful and I will not allow you to function. That is now accepted, and there is no longer any fight between the judiciary and the executive authorities, etc.
So, thank you, sir. So, sir, there's an add-on question to it, that there are these presumptions that on one hand it is said that a draft should be very comprehensive. It should encompass all facets of a case. On the other hand, there is a thought which is propagated that any kind of a document which is made should be as little as possible, as less number of paragraphs, as briefly as it can be made. So what is a better way of drafting?
I tell you, not too big and not too small, because you can't say that make it very small, because then it will create problem. And they say, but what is this? They say, but the Parliament is saying nothing. then the court will have to interpret and say, he said nothing, so I'll do something what is missing. So they must make it, find out, number one, find out parliament, by parliament really begins with the person, parties in those who law minister, etc. of the party in they'll have to think that all right, we want to make such a law. So how to do, what to do, they must do two things, put it clearly what they want to say. Because don't leave anything for then the court, it will go for court, someone will say, you have not said so, or you have wrongly said so. So try and be good. In fact, in parliament also, there are many lawyers. So ask those good lawyers to find out that we want to make it. What do you suggest? Can I do this? Can I not do this? Can it be constitutionally valid, etc.? So that is given to parliamentarians, probably more about the law, not that non-lawyers, parliament members can't do, but some of them are very good, they can do that also. They do it and then make it and do it in a way that is not unconstitutional. And if you just do that, I want to do this, so I make this law. Now that is no good, because if you want to do something and want to make, but you must see that what the law you make is not unconstitutional. And that is very important for the people who make the law.
Thank you, sir. Actually, very insightful, and I'm quite sure that there's a lot that everyone will want to dwell more into this particular thought. So just in line with that itself, there are a lot of young lawyers, so first generation lawyers, to say, who have this thought that how exactly do we proceed in a career? What are the kind of things or how that we should be benchmarking? Not everyone can or wants to become probably a part of the judiciary or the judicial setup. Some people think about government panels, government whatever postings can be there available by lawyers. There are various facets. So what is?
Yeah. Now you see, I find large number of students say that the day I pass law, I want to get into some job because I want to start getting the money. Now, or he wants to get a job. Now, I think they must understand that when you've done your examination pass, you have not yet become a full lawyer. So unless after you are a lawyer, after you have passed the LLB, you must practice the law. You must be in the court, and preferably you should be in the lowest court, the district court. You should have, because district court, lot of things happens in district court which does not happen in the Supreme Court and the High Court. And you must know that in the beginning. And then you can go to High Court, and then you go to Supreme Court. But our many great students say, oh, I want to go to Supreme Court. What will you do in Supreme Court? Nobody will allow you to argue in Supreme Court because you are youngsters, you are just gone. And how will you understand? Since you don't argue, you can't understand. So it is where everyone wants to say, and then perhaps they will write on that I am advocate Supreme Court. All right, you call it advocate Supreme Court because you have gone there. But many people write, even they are in district court, they are also write advocate Supreme Court. All right, everybody is advocate Supreme Court because every advocate has a right to go to and argue in Supreme Court. But that's not the point. You must do something, your own work, preparing a thing. There is a case. There is to start with a suit. You're a plaintiff, then how to make your plaint. You are on the other side, and then you'll have to reply to the plaint. So what will you write? Now start thinking it and start preparing, because you're in the college, you have done a different things. But when you go in the when you become a lawyer, you will know that there is A and there is B, or it is non-A, whatever you call it. There's A and non-A. So you have to think of A and say, A says this, is he right? How is he good? And you are arguing for A, then you will say what is good. Then you should also argue for B and say, no, A is wrong, totally wrong or partly wrong. And the court will decide whether A is right or B is right, or whether A is right for ABC and B is right against whatever. That is what the court will decide. So this thinking is very, very important. And do not start thinking that you become a student and you have become a LLB. So you have become a great lawyer. You are not become a great lawyer because it requires your functioning in the courtrooms. Your college is good. It's necessary. If you don't have LLB, you can't come and practice. But that is one thing. But then also those students who have just been fooling around in the tea and coffee all the time and not in the classroom. I don't like these students. They say, all right, but this teacher is no good, so let us go and have a coffee. But you are missing something. All right, and don't start thinking that teacher is bad, etc. All right, some teachers are good, not good, etc. But if you sit there, then you learn. Even a bad teacher can teach you something. You learn and then find out that this is bad. As I say, you can always think, but if you unless you work hard and think, these are the two things I'll ask the young students, that please work, please, and don't waste your time. Any time which you waste today, you're lost for your whole life. It will never come back in your life. And also have good friends, because there is some law students want to go for anything other than the law. They want to go, let's go here now, today we go this, that, etc. It's all that. And I found many times that the rich people's children are not much serious about the students, because they have a lot of money. So they have a vehicle, they have a car, some of them have a car and a driver, or they drive. So all that, this teacher is no good, let's go and have with my car, come along. So he will also spoil 2, 3, 5 other people also to sit in his car and do it. So please don't do it. What I'm telling you is some of the good dear friends may not like, but I'm telling you because I'm reasonably old man, so I know I practice a lot. I practiced for more than 57 years as a lawyer. So I can say this to the young students. In some of the students who come to me for 1 month, etc., they come for this now compulsory. The college also wants them to go. So I beat them every day. 30 days they're there. Beat them. Not illegal beating, but legally beating. And at the end of it, perhaps they are happy that I was good in beating them. That's all. My friend wants to tell me that I'm a first generation advocate. Yes, it is true. I'm a first generation advocate and who had studied in Gujarati medium. So that's another problem I had, was that problem of English, but if you work hard, then you learn and you think works, But there are some objects and problems. Those who in either I was in Gujarati, somewhere in Hindi. So if you education there, then you have more problems, because for the lawyers you have to speak in English, because everything our documents are in English, and the courts also listens to us in English. So even if you have not learned English, you must learn English. And best thing is to talk to each other. If you talk to each other, and then of course you can say, well, this idiot does not know, he does not say this or that. That idiot will improve and become a good lawyer. Yeah. Any other question?
Yes, sir, absolutely, sir. Every single thing that you're saying, sir, it's imbibe it in a section. All of it means a lot. So there is another question which comes with respect to people who want to do their LLB or who want to get into the practice after a certain age. Say about people who want to get into practice after 40 years of their age or maybe 50 years of their age. Then, sir, what is your advice to them?
You mean those who have done some other work at the age of 40 years, they want to become a LLB? And yeah, you see, it is possible, but they will have a little disadvantages, because those people who are of his age, if you have started from the beginning, but you're hard workers and you work and think properly, then you will do well. Because ultimately, the judges and the senior advocates, if they find that here is a youngster who has come and he's giving work to me, good. Because all these today, there are too many law students, and therefore, lawyers are also say, what can I do? 10 people are telling me every month that I want to come. How can I have so many people to us? So that is the problem. But if 5 people are taken or 10 people are taken, out of that you will find that 2 are good. So keep the 2 and other are I going to 1 month you get out. So you have to work very hard, and the students should understand that you cannot fool. You can't fool anyone. So therefore, you can only fool the canteen in your college, but otherwise you can't. So you have got to work hard, and otherwise you will. The system will throw you out. Nobody will write that you are thrown out, but you will system throw out. That's why I tell all the interns who come to me that I have got something to beat them. Of course, I don't beat them, but I threaten them. So that the threaten is not illegal. Beating is.
It's just so kind. I pray that's a thoda हमें भी डांटना थोड़ा threaten us also. We'll also become more focused and dedicated. I'm quite sure. So there is a question from Mr. Ashish. Ashish, do you want to ask a question or should I ask on your behalf? So again, I request that people who want to ask sir also, you can please go ahead and ask sir also. But I request you to kindly share your question in the chat box first. So, sir, Ashish has a question. He says that, sir, how can a first generation lawyer sustain himself or herself during the initial years of practice?
Well, that person has to work 5 times more than the person whose father is a lawyer or a judge. So you work 5 times more, and you will still suffer for some time because, as I said, if you are a son or daughter of a judge or a lawyer, you'll get a lot of work from beginning. You will not get, but if you are very good, then within 2 to 3 years or 4 years, you'll start getting a lot of work. You should be ready in the beginning. You'll not get, but when you are not getting money, you start earning, working, and do a good work. Then people will say, yes, that man is so and so's son or whatever, is no good. This man is a youngster. He's not related to anyone, but he's so good. And that so good is something will come up. Because I was one of those so good because my father was a primary teacher. So I had to work on my own. And my first time I went was a bicycle, Atlas bicycle for rupees 114 I had purchased to go to the college and all that. So that is it's all right, but it's good. But I'm not saying anything about me, but you have to work. And if you work, you will be successful.
It matters a lot when it comes from you. Then everyone, I understand, will be able to take it better. So obviously I have a lot of questions, but my question I'm refraining from right now. I'm only trying to ask questions which are being asked right now. There is a question from Mr. Sumit. Mr. Sumit, you want to ask? So I will ask on their behalf. So there is a very big problem which comes first of all for young law students. I'll start with because initially getting acquainted with judgments and that too long judgments. So there are so multiple judgments and very prestigious ones in our country which run into thousands of pages. So is there any efficient way or effective way of reading such a large judgment or
Well, you see, this our judges are also have no business to write 1,000 judgments, page judgments. They are good old days. Judges were writing judgments themselves, and they used to write 3-page, 4-page, excellent judgment. Privy Council people, members were doing by handwritten, excellent judgments, 2 days. Now the trouble with our judges is that they got one stenographer, 2 stenographers, force of stenographers. This will come and say, now dictate this. I dictate this. Note down this 5 pages to be added in this, which is not correct and it's not good. The people want to know your judgment as to what is the principle of law you have laid down. Of course, you have to give some basic facts, but this some of the judges who want to write a big judgment and to show that he's making something wonderful thing is not correct, because nobody can read all the judgments, and they should be ready. They should know that that's just right. The case you are not so much bothered about the facts, but you have to give some facts to see that how the judgment is to be given. And to give it not a very long judgment. This is good for the judges. And I think what you should do is they should say that the stenographer should be allowed only 1 hour to a judge. He should not be allowed more than 1 hour. This is not a contempt of court.
Actually, sir, honestly, sir, you're a legend. Obviously, sir, it's not something that you would say, but everyone knows it's a talk of the Supreme Court corridors, the canteen conversation. I would say so too. Yes. So you've seen a lot of also. So in the council, they used to write by their hands. So judgments would be concise and very precise. Today, sir, there is a problem. So again, this is an add-on question to this only. That how to find the arbiter and how to distinguish the ratio of the judgment in such a long judgment. For young lawyers, it's a very big challenge, sir.
You are right. You are absolutely right. And they have no business to write such a long thing, because then even if he reads also, he will not know what he has understood, what is the arbiter. So arbiter is very, very important. And on that, it is, therefore, there are men's judgment, the judges have to give a longer judgment. I don't say that you have to only stick to not more than 5 pages. I can't say so. But there's so many large number of pages saying these are the facts of this, these are the facts. It's not necessary. You very briefly say. And lay down the principles of law also. Say so and so has argued this, others say. You don't have to write that X so and so argued. He argued for 4 days and then he said this. Right? Pick up the points, what he has said. But that is more difficult, and therefore this is simpler, because poor stenographer will type out and say, write this many years said 5 pages, and other man has said 8 pages. But that is a difficulty for everyone, and therefore it should be, as I said, that give only 1 stenographer to every judge, so that he is not dictating too much.
It's just wonderful, sir. And I hope, sir, that I understand, sir. Honestly, myself also understand that what you're saying right now, I will obviously keep reflecting on this more and more, and eventually at some point in time, it will actually trickle down to us what exactly is the intricacy and what you put behind it. It's really wonderful, sir. So there is this question. So again, going on in the line with young lawyers only, that so it's not always that a case is won by an advocate. So first of all, so how should a young lawyer deal with a case which they have probably not won?
Which they have not probably?
Which they have not won. Which they
not worked. Well, they should work much more and don't go to sleep and find out what is that law, what is happening. And ultimately, yes, it happens something. Supposing when they argue as a beginning and a brief has come, he will be very happy that I got a brief. So I'll not sleep today. I was sleeping. Sleeping is also, you can have 2 hours, 3 hours. As a young lawyer has no business to sleep more than 4 hours, So then carry on, and then it will come to your. But then if they want to go at night and have the whatever in a drinkings, then you are no good for the lawyers. You say a member of the bar, but not their bar. So if you go to that bar, then you'll be in a bad. You can't be in this bar.
Absolutely. So for I understand one thing, sir. One very clearly, sir, thing which has come forward is that uh, I will say I will remember this and I will forever quote you on this that 4 hours is maximum sleep for a young lawyer. It should not be more than that. And it's absolutely, sir. It's very thought provoking. A person, every person for that matter of fact, needs to think more and more in that respect. So for improvement, growth. So about 20 hours of the day, then I have. So how should I plan my 20 hours then?
Eat only twice, not three times. So for that you'll get some more. Eating is also a very dangerous thing, especially for the youngsters, for the lawyers. And they love, and they always go to so many good restaurants and eat a lot of it. So of course the ladies lawyers are not eating too much of because they're afraid of it, the fat. But the men are not bothered about the fat. So that is also a problem. But what I want to say that is they should devote a lot of time, keep on thinking, keep on discussing with each other, and note down. And then again, once you note down, it's different than typing. Of course, now you can do everything. Nobody wants to write down anything. You've forgotten to write, but then you can type out whatever you want to do. But think and discuss and talk to your colleagues, friends, that this is what I want, what do you say? So they discuss properly. You have enough time, 24 hours is quite enough time for you to work if you want to work. But if you don't want to work, then nothing can help them. So earlier they start working hard, better they will be earlier as a lawyer.
Absolutely, sir. So there is a question from Miss Raji Nathani. Raji ma'am, would you want to ask the question? Ma'am, please go ahead.
Okay, you may go ahead, Keshav, please. Yeah.
Right. So, Sir Raji ma'am, her question is: so young and new lawyers, should they necessarily work under someone, or is it advisable, or is it not advisable to start their own practice?
They should not start in the beginning at all. They must go with some other senior lawyer and learn from him, because if you start working, then you don't know how to do it. So how to do, you must learn from a senior. And according to me, minimum 2 and maximum 5, it should be in the beginning after you become a lawyer, be with some good lawyers. But work with that lawyers. Prepare for that lawyer as if you are a lawyer. And because then gradually, what happens, your senior may have many matters in another court, and other court tells your junior that, sorry, I will not adjourn. But your last time also your junior did not come. So lawyer did not come. So now you have to argue. Now if he's to, then he has to argue, and the senior can't say. Normally senior will always tell, no, you will not argue, I'll argue. But what can he do if the judge says, now you argue? These are opportunities. But that time the junior will say, oh, I'd come only as a junior, I have not come for arguing. Then it's useless. You should be ready for argument. And then you will help. So, I know if they are ready to argue, then even senior is arguing, suddenly a question will be asked by the judge. And that senior has not read enough because he did not have enough time. He has too many matters. So then if the junior gets up and tells the senior that the question of the judge, reply is this, and this is the page. So the judge will watching that, oh, yes. Then he will say, so the judge will say, but what is the name of this young lawyer? He said, his name is so-and-so. Very good. You are a good lawyer. So all this happens. And if you do nothing and you go to sleep also in the court, that is also possible. But you are allowed to sleep there. But you should not make noise. That's all. Otherwise, so.
As long as one is not snoring.
Yes. It
So there's a
interferes.
follow-on question to that.
it interferes with someone else, lawyers sleeping also.
So maybe we should have a conversation on just jokes at the bar, probably something like that, with your blessings, sir, hopefully in the future.
No, but whatever
So,
I have
anyways,
said is
I'll
not a
just
joke. Whatever I have said is not a
no,
joke. at all.
absolutely not.
It's a reality.
So it's a
Thank-
blessing. It's a blessing to be
Thank you. Thank you.
getting all of this gold from you. No, still we have time. So I'm just grateful for all that is coming from you. So then there is this question which is very important, which comes forward, that for young lawyers, how do we get work? Most important.
They to get work, they must work very hard for his senior. Prepare very well, because no client wants to come to a junior. He said that, my God, my case is important. What will happen? This person is just become a lawyer. I don't want to give the brief. And he's right in his point, because he wants to go. Just as even if you go to a doctor, you'll not like to go to a doctor who has become today a doctor. You'll say, oh, no, this man is very good. He had done this, this patient, he had done. So it is natural. So that nothing, you can't do anything. That the client will say, I don't want to go to a person who has just become a lawyer. That which is that is permissible. But therefore, you have to work so hard so that the students, the clients who are working for your senior, they will come to know that this youngster is good. A judge is asked a question to the senior and he is unable to reply, and this junior quietly tells that, sir, this is the reply. And then he will tell that, and the judge will know. Other lawyers who are sitting in that courtroom will know that, oh, these are youngsters, and the senior did not know, but he came out with it. So all this takes time. But if you do well, then once you come up, then you keep on going up and up. And then nobody can stop you. But it was only you have to work, and nobody else can help you. You have to, each student has to work as soon as when they are student, and where the beginners as a lawyer.
Absolutely, sir. Absolutely. It's very well put and so very thought-provoking, actually. So, in line with what we've been able to learn mostly today from you, sir, is that so in the learning process, so there has to be a senior comes and then we learn and then we grow and progress in the career. So, one very important question which comes in this aspect is how exactly so two parts. How do we identify which senior to associate ourselves with? And two, sir, how do we get into their chamber?
Well,
How do we get them to accept?
you should go to a senior who has a lot of work. But the point today is there are too many students. So it is very difficult, because everyone, someone wants to take 2 juniors, 3 juniors, but there are 30 juniors are asking him and say that make me. So therefore, you try wherever you can. But once you become a junior of work so hard so that you will stick into there. And if you go there and don't do any work, then after 6 months, the senior will say, you get out. No, you're no good. You're not helping me. You're not. And why not? You're not doing anything. Why should he keep you? So, but if you work very well, then he says, yes, please stay on, be with me. So it is the choice is of the young lawyer, whether he wants to be good with the senior lawyers or not. But it depends on how much he works and how he works, etc.
Absolutely, sir. Absolutely. So, another question which comes in line with this is so seniors and chamber practice is one part. A confusion which lawyers have at a very large extent, I would say, initially during the initial few years itself, is whether if to or go for any law firms or for chamber lawyers who are practicing through chambers?
Well, if you can go to the law firm, it is better also. But it all depends on wherever you get it. Today, in the beginning, wherever you get it, you get into. But according to me, they should first start with the lowest courts. Because most of our students have this idea, I want to go to a Supreme Court lawyer. But what will you do in Supreme Court lawyers? Because nobody will allow you to do anything in Supreme Court. So they should learn in the lower court. Lower court has these questions. The people will be examination, cross-examination. It does not happen in Supreme Court and High Court, not at all. So you learn it in the lowest court, district court, and they will not get much money. But most of the students say, no, I want money. And then what is this? They think, how can I go only to the district court? I'm a very good student. I want to not. It is, you will learn much more in district court than any other court. But most of them want to go to the Supreme Court, which is total nonsense, because in Supreme Court, nobody will give him any work. He will only hold the papers of the senior.
So, but I'm quite sure that getting to hold your brief is in itself very enlightening, and in itself it would lead to a lot of learning. So in line with that, in line with what you just mentioned, sir, just going with that flow itself. So, what should be the relevance of financial pecuniary benefits for young lawyers when they're choosing to go with seniors? Should they look for money, who's paying more, or should they try and go in?
According to me,
how do you think this?
It's of course some person who has become a lawyer needs money immediately. His parents can't give him meat. The parents have given him food up to the passing, becoming a lawyer. Now they don't have or they don't want to give. Then they have to go to someone for money. But those who have little okay with money should go to someone who may or may not give him money, but he will give him work. So that's a choice. But the problem today is that where will he get also is very difficult. There are too many students coming out. So people are also fed up that 10 people, 15 every month asking me, what can I do? And they are right, students are right, who have become a lawyer, that I want to go, and therefore they right, but then there's a limit. There will not be enough chairs in their office also. So how can they have so many? Then the youngsters will say, no, I'll stand. But that's not how it works. So there's limits for taking how many juniors you can take.
Absolutely, sir. I can only try and understand, sir, with your experience, the kind of facades that you would have seen around and the entire infrastructure of law. It would really be very, I think, beneficial for anyone who refers to the class again and again. I would ideally suggest that to every single person who's here. I know for sure that I will have to, and I will have to go through the class once again. So, sir, again, sir, we're at the end of the time that you allotted us so graciously, sir. So, just one question which comes in with respect to a very fundamental bit of law, which is around ethics. So, so this is a question by Mr. Sumit Dhaya. Sumitji, would you want to ask the question yourself? So I'll ask the question on his behalf. He says, how can young lawyers maintain a balance between personal morality and professional ethics when representing clients accused of serious crimes such as murder, despite having knowledge of their guilt?
Well, I tell you that this can become, in the beginning, they can think that why should I argue on behalf of a murderer? He is murdered, but that's not correct. Everyone is entitled to have a lawyer, and therefore, to begin with, they should take up any brief which comes to him. They don't say this is a good man or a bad man. Even a bad man has a right to argue in the court. You can't tell the advocate that this is a bad man, he has done this, I will not. No, he has a right to have a lawyer. So they should get, but for the youngsters, just give anything which he gets, take it now. Don't too much of money if he can wait. But so that priority should be learning and getting some opportunity to appear or draft, etc.
Absolutely, sir. Absolutely. I can understand. So just one thing, this is my personal this thing that I want to ask, because sir, I've studied from Faculty of Law, Delhi University, sir. And I have a lot of friends who have come from across the country and who have studied with me. Today also, so how it is placed. So you're also from Government Law College. I tried to get admission over there also at some point in time. But so when people are traveling from one state or one city to another, and then they get to complete their law, they start practicing over there. So managing personal finances, even just going to a court, that also requires some kind of money. Then rents have to be paid. Then some kind of whatever conveyance and all is there. So everything's online. All of these SEC online and Manupatra, these are very expensive things otherwise. So, how do you, so any word of advice to such lawyers that, so you would want to give that, how the initial few years, which are the toughest, where there is practically no money?
Well, I can't give any solution. This is the reality. There are too many new lawyers and too less. So they have to accept, in the sense if someone said that, give me good lawyer, give me good money, it's not possible. So, but if they are very good, as I said, and they work, then they'll come up. Because the seniors also watch and find out who is good and who is working.
Absolutely, so I understand. So it's very clear that everyone should be aware of what exactly the manner is working. So, so I think there's just one final question from Miss Himani. Himani, do you want to ask that question in short, please?
Yeah. Can I go ahead?
Yeah, please.
Yeah.
Namaste, sir. My name is Himani Kharai. So, as the topic of today's session is do's and don'ts for a young lawyer, so I would like to ask something in the ambit of it. It's a very basic question as a young lawyer. Like you quoted hard work as key ingredient in law practice. So can you please elaborate on hard work and which are the key areas which need hard work in law practice?
You see, wherever if you join to a lawyer who is doing criminal matter, then you start working on criminal. If someone is doing some particular law, constitution, then you start working. You pick up what your senior has to argue. So depending on that, you start working. You as a junior has no choice what I want to argue or to which lawyer should I go, whom I do. Whoever gives you is good enough, because you're not going to get too many of you are coming up from all over the party, all over the country. And therefore, you just don't have too much of expectations. You have to work very hard, but if you are good, then within 1 or 2 months, you'll start getting money. And then the senior will say, yes, please stay on with me. You're very good. So that is what you have to do in first 1 or 2 months. Don't expect money, but do good work. Then you will come up as a good lawyer.
Yes, sir. So can I add one more question to this?
Yeah.
So does
sir, last question.
Yeah, this is the last, sir. So, sir, I want to ask, does arguing in courts only make you an advocate or justify you as an advocate? I mean, where does research and drafting stand in the practice of law?
You see, according to me, they should do everything. You will not be a good lawyer if you do, I only draft or I only go argue. You have to do everything. And then you don't know what work you'll get, but you should do everything. And one brick you pick up and start preparing, working. Then you say what I'll argue. Then you have to say, but my opponent is arguing this. So what will I reply to the opponent? Where the judge will give a judgment after hearing you and your opponent. So you will have to say, accept my arguments and don't accept the argument of my opponent, and vice versa. So you have to work everything. There is nothing like it. And then out of that, the judge will ask you some question which you have never thought of it. Then you can't say, I can't reply because I have not read, or you have no business to ask this question because this is not the point. No, he's a judge. If he's asking, you have to deal with it. Therefore, sometimes if the judge is not very good, also we also see you're a wonderful judge.
Thank you so much for the enlightenment, sir.
Okay, thank you. Thank you very much.
So thank you so much on behalf of all of the participants, sir. We're absolutely grateful to you, and we hope and pray that we get so many more further opportunities to learn.